Hello and welcome to the next installment of the VLF Video Educational Series. Today's topic is calculating damages under the Fair Labor Standards Act, or the FLSA. My name is Charles Vethan.
I'm Joseph Colvin.
I'm Joseph Lanza.
So Joseph, under calculating damages under the FLSA, in our last series we addressed what the work week was and a record-keeping requirement. So what are some damages that are available to an employee under the FLSA?
Well, there's several categories. So the obvious category is the amount of overtime that they are actually owed for their services rendered on a week-by-week basis. In addition to that, the court can award what's called liquidated damages, which could be in an amount equal to the actual damages, which basically doubles the dollar value. Attorney's fees are coverable under the FLSA, which can be significant. And finally, there's a chance for a plaintiff, under certain conditions, to extend the statute of limitations, which basically increases the time period for which they can recover.
So Joe Lanza, what are the requirements for a court to extend the statute of limitations from 2 years to 3 years?
Well, statute of limitations is a time in which you can bring your lawsuit. If you wait too long, the statute of limitations bars you from filing a lawsuit. Generally, in an FLSA case, the statute of limitations is 2 years.
Can that be extended beyond 2 years?
Yes, that can be extended to 3 years if you can show that the employer had no good faith basis for compensating the employee the way they did in failing to pay overtime.
So Joseph, in determining what a good faith basis is, what are some arguments that an employee may make and that an employer must be prepared to defend against to extend that statute of limitations from 2 years to 3 years?
Well, there have been a number of cases on the topic. Some of them include the situation happened before, a previous lawsuit. Some of them have included a failure to consult legal counsel. So a court's held that failing to consult in depth with an attorney about this specific job duty for this specific class of employees is enough. The failure to do that is enough to show that the violation was willful under the FLSA, extending the statute.
All right, so you mentioned consulting an attorney. So is that a reason an employer has to say, look, we didn't act in bad faith, we acted in good faith because we spoke with an attorney?
It can be, as long as it's not a mere rubber stamp. So there's cases that if you just call your attorney and say, hey, we're paying them without overtime, is that fine? And they say, oh yeah, that sounds fine. That's not going to work. There has to be a detailed analysis of the specific job duties of the particular employee.
So that's an interesting point, Joe Lanza, because if an employer relies on the advice of a lawyer to determine whether an employee is entitled to overtime or not, as we know, communications between a client and an employer are protected by the attorney-client privilege. What is an employer to do in that position to show that, yes, we consulted with an attorney, yes, we had a basis for it, without destroying the attorney-client privilege?
Well, in that circumstance where the employer is relying upon consultation with an attorney to support the exemption, the employer is going to have to make what's called a limited waiver of the attorney-client privilege, limited just to that narrow specific issue and not to other communications between the attorney and the employer.
So what are some documents that an employer should make sure that it has from its attorney in determining whether employees are exempt or not? So what are the key documents?
Probably document number one is going to be an accurate job description, not merely a job description. An accurate job description based on interviews with those employees and their managers. The second is going to be probably what you would call an opinion letter, which is a letter from the attorney to the employer saying we've evaluated this particular set of facts against the FLSA, and based on our analysis, these employees are in fact exempt.
All right, so as I understand it, the attorney has to review the job description to find out what the parameters of the discussion will be, and prepares an opinion letter that says, based on the information that I've been given, it appears your employee is exempt or non-exempt.
Exactly.
Well, thank you for joining us today on our discussion regarding calculating damages under the Fair Labor Standards Act.
Your problem is our business.
For more information about calculating damages, please see our website at www.vethanlaw.com. We'll see you next time.